I would not seek to deal with issues of how extinguished or distinguished this debate has gotten. I will simply try to have its principles and merits replenished. Mr. Speaker, because there was an overflow that saw the principles and merits apparently, especially with the last two speakers, depleted. Mr. Speaker, I notice my good colleague, Mr. Rohi, mentioned that it was since 2010 that Commission of Inquiry was held, and thereafter, very shortly, it went to the Select Committee. And all these recommendations, when they had a majority, could have been passed by them when in government. In two parliaments, 2011 and then the 2013 one. But they didn't pass it. And they're now coming here to lecture us as to the moral authority or the lack of that we have in relation to wanting to do, as they describe it, piecemeal. Well, I would like to tell them that piecemeal is better than nil meal. Nil meal. Because that is what members over there, when they were in government, honorable members, when they were in government, they did not seek to do anything about that Discipline Service Commission or the recommendations of its Select Committee. And so we said we were better, and we are amending here. Yes, Mr. Speaker, this goes a far way, and I will show the merits of each of these amendments as to why it goes why they go a far way. This has no political mischief about it. Absolutely no political mischief. It is, if we were to ask about political mischief, it might have been the lack of amending prior to today. That probably would have. But I don't want to go further than that. I want to say, on the issue as to what the law is right now, the Coroners Act, Chapter 403, there is a meaning for coroner. It means a magistrate of the magisterial district, or if that magistrate cannot conveniently or speedily be found, or is unable to act, the nearest justice of the peace who is able to do so can become the coroner. Every justice of the peace shall be ex officio a coroner. That was this law. If they didn't like this law, as Mr. Rohi, honorable member, is saying, they could have amended that. But they didn't. Today, we are passing an amendment here that says exactly the same thing, but we have added a piece. And this is where we do not have any political mischief. That it is the Judicial Service Commission that will appoint. Judicial, not Mr. at AG. Not the distinguished AG. It will be, notwithstanding those sections, the Judicial Service Commission may appoint fit and proper persons as coroners. And so we are not going to be political about it. The Judicial Service Commission is made up of who? The Chief Justice, those same persons, the Chancellor, and whosoever else constitute that very important body, and they are insulated from any political mischief, in my opinion, unless you want to now feel that they are going to do political mischief with the appointment. So let's get it clear. Apparently they didn't read the amendment. This part of the law goes a far way in taking care of what the honorable member was trying to give the impression of, that it is not being taken care of. And so that must be understood. The very first section, The Principal Act is amended by 3A, and 3A states that notwithstanding anything there in sections 2 and 3, the Judicial Service Commission, they appoint fit. All right, well, read the act, man. We won't listen. Read the act. This is the law that we are passing. Yes. And that is why I want to replenish the debate with making those points. Yes. The magistrate then, what we are also dealing with, and it is confronting the issues of the Discipline Service Commission, is because in these magisterial districts where these deaths unnatural happen, they're so loaded with work, they might not be in a position to do the inquest. And that is why within these geographic, the counties, that is, we have not more than one that could be appointed by the Judicial Service Commission in Essequibo. And what it is, in relation to the county of Demerara, there shall be at least 3 coroners, because there were many unnatural deaths that occurred here, and that has a serious backlog. So we will have at least 3 in the county of Demerara. You could have 5, you could have 7, but at least 3. And in the county of Babis, at least 2, and at least 1 in the county of Essequibo. When these coroners are appointed and the files go to them after the police investigation, and there are lots of files there, because I understand all of those unnatural deaths that occurred during that period, that is the backlog, are there. They will have to go now to the coroner, and the coroner will then call up witnesses, and he could even summon additional witnesses. And that must be understood, because the existing Coroners Act has that as the power of the coroner. The coroner has these magisterial functions. And under the Coroners Act, Section 27 and 28 and going on to a number of other sections, they make it quite clear that if the coroner demands a certain witness to come, the coroner must have that witness there. Otherwise, like a judge, you can make sure that that person, if he does not come after a certain procedure, he could issue arrest warrants and all of that. So we do have the powers under the Coroners Act in relation to these matters. What was the problem, however, was the backlog of the magistrates within each district having these difficulties, because they have quite a lot of work to do. And what do? We now have added more can be appointed, and appointed by the Judicial Service Commission. The impression is given here by Honorable Member Mr. Anamaya that this is a cut and paste piece of legislation from Trinidad. Well, what's wrong with cut and paste if it is going to meet the requirements that we, the executive, see fit? Oh, yes. All right. But when you got this amendment, what was wrong if you had come up and manufactured your own amendments so that we could debate it here? Why didn't you do that? No, but we're trying to make at least the Discipline Services Commission. You sit there knowing your duty if you feel that we should have done better, but you don't come with your better. You remain silent like a suspect. Yes. You remain silent like a suspect. And now you come and regard. I'm sorry, I withdraw that last description, sir. Yeah. So I am asking that they over there, since we can only cut and paste, let the honorable members across the floor, Honorable member,
you're referring to honorable members opposite as?
Opposite, yeah, opposite.
As?
As honorable members and colleagues over there, I would like them to do better than our cut and paste job and let them be manufacturers. Be the manufacturers. But you don't want to. You don't want to. There is the other argument that he made. We have to legislate the qualifications. Legislate the qualifications. Well, in this Coroners Act, we know basically what magistrates' qualifications got to be. We also know what justice of the peace qualifications are. But in view of the fact that we are, in a sense, depositing the appointments to the Judicial Service Commission, and knowing what this act requires and what kinds of investigations, because there's a whole chapter on how the investigations should be done, the Judicial Service Commission can deal with that, rather than we doing it here. But even so, that we did not do it, I would have thought that you could have come up with some qualifications in an amendment. But you don't want to manufacture too. It would appear you don't want to manufacture. All right, it doesn't matter. You have come with amendments before that you said has not been passed. Oh gosh, well, that doesn't mean that you must not manufacture. Let the public out there know that you come with something, but you didn't. But I want to make the point. Sorry. Not abusing, I'm rebutting. I am merely rebutting them, point by point. Yes. Material witnesses not available. Who might have caused this? After all that which transpired years ago, and there was no coroner's inquest held, who caused that? At least within the first 8 months of our government, we're trying to do something about what happened long time ago. So it's we who cause material witnesses to be absent, if they are indeed absent today. It is those honorable members in the opposite side. All right, let us deal with Walter Rodney. The argument was that we must have fixed timelines for the inquest. But that is extremely difficult to do. Take, for example, the Walter Rodney Commission. They had made a certain... Again. Sorry.
Honorable Member, are we staying on the coroner's bill?
It is. This is a very important point I want to make.
Honorable Member, every point you make is important.
That's correct. I am sticking to it.
But I must ask the honorable member to remember that he's speaking on the coroner's bill. At this stage, we deal with the merits and principles of the bill, and I must strongly urge members to remember that when they speak.
Thanks very much.
I do not believe I can accommodate the diversions and digressions.
Yes.
Please.
Timelines are always going to be extraordinarily difficult to fix when you're going to have certain investigations. In the last commission and the one that is going on, we had fixed, I think the government over there, at that time had fixed a certain timeline. It could not have been reached. Then this government got into office and we fixed another timeline. And then because of the request of the commissioner, we had to fix another one. How much times? About 2 or 3 times. For that same commission of inquiry that I'm talking about. The Rodney Commission. And so it is always going to be difficult to legislate timelines for inquest. And that is why we couldn't do that. And I want Mr. Anamail, honorable colleague on the opposite side, to understand that. You can't legislate sometimes these difficult questions, because assuming the witnesses don't come, and then you say it's a 6-month period, and then when you then get a summons for him to come, the 6 months is up. What do we do when the 6 months is up? Do we then stop that investigation forever? No. So I wanted to be urged upon members over there that sometimes the points you make are not well thought out, ill-advised. And to that extent then, you must appreciate at least we come with something. honorable members over there never came with anything. And I urge you, with those points made, that you please support this rather than send it again to Select Committee, where that one went and nothing happened. Thank you very much.
Mr. Speaker, I'm always placed in this invidious position whenever I have to respond at the end of these presentations. When I have to lecture, give lectures in these matters. Mr. Speaker, this is an unusual proceeding in the sense that the cabinet of the government says they want this bill to come to Parliament dealing with this section and this clause. And when the bill comes, sir, the members on the other side say, no, we're not dealing with this. We want you to deal with that. We must deal with that. It's so unusual and unheard of. But as you say, sir, this is democracy. So, be as it may, the cabinet of Guyana, of the APNU AFC government, says this bill must be brought to the Honorable House for passage. That's what it says. And sir, the remit of this Honorable House, is to deal with the provisions in this bill. But sir, the Parliament has been carried and meandered on all kinds of extraneous parts, dealing with all kinds of sections and provisions that are not before this Honorable House, that is not contained in the bill. That's the first thing, sir. So, for the opposition to say to the government, after the government has deliberated on the matter, brought the bill to the House, we're not concerned with what you brought, you must take this. Take what we want you to take. Sir, but democracy does not work that way. And I'm saying, sir, the honorable members on the other side, they are confused by this democracy that they haven't practiced in the last 22 years. Democracy is confusing them. They're confusing them. For example, sir, the honorable member of Mr. Nandalal is complaining about being consulted, sir. He's complaining about being consulted at the convention center. He's complaining about being consulted at the Attorney General's chambers. So what is democracy? What is Article 13, sir? Sir, Mr. Speaker, in the case of a previous bill, there was a big furor. There was no consultation. Stakeholders were not consulted, sir. Mr. Speaker, this bill was laid in this honorable House. It was gazetted since the 13th of November. It was placed on the official website on the 16th of September. Once it's gazetted, you take judicial notice. Any minister or government worth its salt must do their work. That's right. And that's why they haven't failed to do their work for the last 23 years. They're on the other side of this House.
Do your work.
We don't have to spoon food you, but you're supposed to read the official gazette and you'll see these bills. But sir, we did more than that. We did more than that, sir. We consulted with the stakeholders. Mr. Speaker, having spent money to consult with stakeholders, sir, it is painful to hear the official spokesman on legal affairs, not the shadow attorney general, the spokesperson on legal affairs for the opposition, complaining and saying after the private sector sat, the Bar Association sat, he was there. He called it a gaffe. That is what he's saying about consultation that he's asking for. Sir, the honorable member is confused about consultation and what is democracy. On this side of the House, this government will continue to consult the Guyanese people inside and outside of this parliament. when he realizes that this consultation is taking effect and society, members of civil society are coming and participating, he suddenly now decides that democracy only adheres within the walls of the parliament. And that is only in a special select committee. Mr. Speaker, every parliamentarian, sir, who knows his procedure and the rules of parliament, will tell you that a bill does not go to special select committee whimsically or capriciously. If that were the case, no work could be done in the parliament. No bill will come out for passage. Only complex bills go to special select committee. Why would you take a single paragraph in amendment to special select committee? The only reason is that they know, one, that is a campaign promise, and they want to derail it. They want to postpone it. And talking about political this or political that. That's why you over there. You never kept your promise to the Guyanese people. That's why you over there. Mr. Speaker, the president of this country, the Honorable Brigadier David Granger, His Excellency, came in this Honorable House and tried to set a mood. And no later than soon as he departed, the Honorable Leader of the Opposition destroyed that mood, sir, in this House. And then coming to tell us, but the President spoke about this and that. We know what the President is saying on this side.
Yeah. I must interrupt. I must call attention to, in this standing orders, I wish I know every single member here is very familiar with. Standing Order 41. Standing Order 41-7. I may read it while I'm sure all members will want to look at it. It says the President's name shall not be used to influence the assembly. I don't think it needs any kind of interpretation. Honorable members, please observe this provision. Thank you.
Mr. Speaker, I was merely responding to the honorable members Rohi and Nandalal, who invoked the President's name, sir, without demur. But being very familiar with that rule, sir, I'll observe it. Yes, sir. Mr. Speaker, when I spoke on this bill and introduced it, sir, I never approbated or reprobated in this matter. We never cast blame on anyone. I cast blame on no one in this Honorable House or out of the House. What we want, sir, is to have inquests into hundreds of deaths, unnatural deaths. And I don't know why anyone would find a problem with having that. Why would anyone have a problem with holding inquests into the backlog of all those deaths that had occurred during that period of the killing fields? How could that face opposition? I don't understand that. We haven't blamed anyone. The old proverb comes to mind easily, though, that you chew your corn, you know? But I'm surprised at this type of opposition, sir, to a simple bill like this and a simple amendment. A simple amendment. You know? So, Mr. Speaker, therefore, let me respond to some of those. Imagine it was asked and it was submitted and contended here. Why we need all these coroners? We don't need no more coroners. A person who was Attorney General of this country is saying that the magistrates could do the work. And in 23 years, the magistrates never did anything to clear up these coroners' backlog. under that watch. And the question why we have decided that there should be permanent full-time coroners is to clear up the backlog. Hundreds of cases from 2000 upwards. How could the magistrates who are dealing with the current situation day to day, why would we want the magistrates to go and divert from that whole inquest when we could appoint other coroners to do inquests? So it's a simple answer. I don't know what is so hard to understand. And full-time coroners who could now work any part of Guyana, they're not restricted to the magisterial district as the sitting magistrates. And this other question about multiple magistrates in a district, I don't know what the contention is. Mr. Speaker, any lawyer who went to the High Court and made an application by way of a prerogative writ to obtain an order of mandamus commanding a magistrate to conduct an inquiry would know the procedure. But they never did. But this lawyer did. Because when they want to hold an inquest, I went and caused them to have the inquest to be held. They were mandated to hold the inquest. And there is no question about confusion. Because if you have 10 magistrates, some magistrate will be assigned to comply with the order. So I don't know where this contention is coming, but you couldn't identify. There was no political will on that side of the House to get inquests off the ground. And the question of fit and proper criteria. Again, when I became Attorney General, one of the things I had to deal with included the registries. Everyone knows about the headless Supreme Court registry, etc. The deeds registry was like that too. And Mr. Speaker, there was this belief that the registrar had to be a lawyer. And you search any one of the acts, and you found no qualifications for registrar. Yet the Judicial Service Commission has been appointing registrars. So it is nothing unusual. You don't have to spell out the qualification for anybody. The Judicial Service Commission will determine the qualifications, and they are an independent body, and that is the remit of the Judicial Service Commission. So you don't have to pull out qualifications and say this and say that. The Judicial Service Commission will determine who are the fit and proper persons. So I don't know what's all this conjecturing and this type of meaning. The only reason I could really attribute for all of this confusion is that some people just don't want these inquests to get off the ground. They don't want people to have closure. Why else? People must want to know what happened to their family. They have a right to know. And this government will ensure that they know. And Mr. Saturday Osa, his relatives are calling for an inquest. They're calling for an inquest that was never given to them by his own colleagues. And he would have an inquest too. And I don't know when the Judicial Service Commission appoints someone, that appointment is a political appointment. So all these arguments are fallacious, specious, and must be rejected out of hand. I don't want them to warm me up now tonight. Mr. Speaker, we again, the contention that the bill did not rectify some section in the Coroners Act. Mr. Speaker, that was not the intention of the bill. The opposition has to take this bill brought by the government, talem, qualem. They have to take it like that. How could they tell us that this bill didn't rectify that section and that section? Our cabinet did not decide that. The cabinet decided that we needed to have more coroners so that we could deal with the backlog of all those cases. that are not heard. And were not heard under the opposition members, sir. That's what it is. Nothing else, a simple amendment. Why should this go to some select committee? For what? The only reason is to delay. Delay it. There's no intellectually stimulating exercise in this. Nothing intellectually stimulating in this. And in the judicial and the discipline service corruption report is I made the submissions. I made the submissions. And I could tell you all the submissions I made about coroners. And one of the submissions was that when the police caused the death of someone, the police should not collect the body of the person that they shot and killed. Because when the post-mortem is done, no warhead is found in the body. And if you don't find any warhead, you can't say it's the police. So if the police shoot the person or collect the person or go with the person, that cannot work. So we're saying to you, right now, only 7 months in government, we will do what you did not do from 2000 to now. And we will not encourage you to suggest to us what we must do and what we mustn't do when you had the opportunity to do it all those years ago. We will not take that from you. So, Mr. Speaker, this bill is a simple bill. And it's a simple amendment is being proposed. And the amendment, sir, if I might respectfully refer you to the amendment, it says clause 2, big A 2. Substitute in the county of Demerara, there shall be at least 4 coroners. In the county of Berbice, 3 coroners, and the county of Escrib at least 2. Who shall be full-time coroners? Says that clearly. And clause 3, big A, subsection 3, for the words 3, substitute the words 2. Simple amendments. And these are amendments, sir, we are going to move in this honorable house to amend the clause, the simple clause in this bill. So, Mr. Speaker, without wanting to unduly delay this honorable house, I move, sir, that this bill, I commend this bill to this honorable house.